those who think that impeaching Gachagua is a walk on the park. We are now in the arena where the Constitution and the law applies. The courts after the High Court, any party that will lose this matter will go to the Court of Appeal. Any party that will lose this matter will go to the Supreme Court. And I'm telling Kenyans, the deputy president shall be in office until around March 2027.
Some of the country's best lawyers are pouring through the constitution and a ton of documents to urge their case. The lawyers and their teams, who don't come cheap, have raised questions and put defense on whether the three-judge bench put together by Deputy Chief Justice Philomena Mwilu was properly constituted. This was the first hurdle yesterday in the hearing on the impeachment of Deputy President Rigathi Gachagua.
Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for refusal, there is no problem. We will hear. If we feel we have to get out of it, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Gachagua wants the three judges to withdraw from 3 cases placed before them on Friday last week. Gachagua, who filed his application alongside David Mathenge, Peter Kamotho, Grace Muthoni, Clement Muchiri, and Edwin Munene, claims that Justice Eric Ogola, Fred Mugambi, and Anthony Mrima were allegedly constituted. In their application, with Mathenge, Kamotho, Muthoni, Muchiri, and Munene urged that the application filed by the Attorney General and National Assembly on Friday warranted the DCJ appointing the bench and fast-track the case was not urgent.
We have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue is speak for the Wananchi and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lords, is this, the issue of bias. And this is bias by the Honorable...
According to them, out of 10 cases that had been filed on Friday, only 3 which had orders barring Interior Cabinet Secretary Kithure Kindiki from assuming the Deputy President's office were placed before the judges.
The files with orders are the only ones that the court is sitting on a Saturday. The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, like in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectively.
Kibe urged that although the law requires the president to nominate a person for the DP's position within 14 days and the National Assembly process the same within 60 days, The same happened within 4 hours. He said the decision was a systematic violation of the Constitution.
The first thing is that the president cannot be sworn. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the.
While purporting the application, lawyer Elisha Ngoya urged that the power to appoint a bench is not administrative but constitutional. According to Ngoya, Mwilu ought to have filed her directions in the judicial system.
That's an important question. How do we move forward? The paradox as I got it, because they don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Brima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and kind of ask that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Senior lawyer Paul Mwite claimed the bench sitting on Saturday was also a gross violation of the Constitution. According to Mwite, the bench was empaneled to set aside the orders freezing the impeachment process. Wanjiku Kamodo, another lawyer, said that she only became aware of the cases being mentioned on the television, despite being a party in the case. She also further claimed that she was not informed that the bench sat on Saturday.
Said our piece, and Elisha Ngoya will be making submission. But my Lord, do give us this a very weighty matter. This E015 in Kiloboy. The orders of your brother, Mr. Justice Mungu, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday? To give the permit us articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
Does the Deputy Chief Justice have the power to appoint a bench of judges of the High Court to determine a matter that has been certified as raising substantial question of law? And if so, did the DCJ Philomena Mwilu authorize the 3 judges she appointed to determine application filed by the Attorney General and Parliament to sit on Saturday? These and many other questions came into sharp focus yesterday as lawyers for impeached Deputy President Rigathi Gachagua and other parties appeared before Justice Eric Ogola, Anthony Mrima, and Dr. Freda Mugambi for the hearing of application seeking to lift an order blocking Interior Cabinet Secretary Kithure Kindiki from being sworn to replace Mr. Gachagua.